Hello and good morning to all. This is Rohit Raj. Welcome you all to my channel, The Lawyer's Web. So today in this video, we are going to talk about minor guardian under the Hindu Minority and Guardianship Act 1956. So in this video, we are going to talk about the minor and guardian explanation, types of guardian and their explanation, and the power of alienation and the guardian appointed by court under the Guardian and Ward Act and the provision of 1 2 provision enumerated on guardian appointed by court under Guardian and Ward Act 1890, and lastly who can apply for an appointment as a guardian. Now let's start our video with the explanation of minor and guardian under Hindu Minority and Guardianship Act 1956. So एज पर दी सेक्शन 4 अगर देखते हैं हिंदू माइनॉरिटी एंड गार्जियनशिप एक्ट 1956 के, तो कोई भी पर्सन जो कि बिलो द एज ऑफ 18 ईयर्स उसे हम माइनर कंसीडर करते हैं। और वैसे पर्सन जो कि बिलो द एज ऑफ 18 ईयर्स होते हैं वो इनफ कैपेबल नहीं होते हैं टू टेक केयर ऑफ हिमसेल्फ और देयर प्रॉपर्टी और देयर अफेयर्स, एंड ऑल्सो फॉर देयर प्रोटेक्शन विच इज यूजुअली द वर्क ऑफ द पेरेंट्स is not seen in the many unfortunate cases जहाँ पे पेरेंट्स अवेलेबल नहीं होते हैं। तो वैसे केसेज में अदर पर्सन अपॉइंटेड एज अ गार्जियन ऑफ दैट पर्टिकुलर माइनर for the protection and for taking care of that particular minor. Now, if we see Section 4 Clause A of Hindu Minority and Guardianship Act 1956, तो वो बताता है कि माइनर वैसे पर्सन जो कि बिलो द एज ऑफ 18 ईयर्स वो माइनर कंसीडर करते हैं, और इन द केस एनी गार्डियन हैज बीन अपॉइंटेड बाय द कोर्ट, then in that particular case the age of that particular minor extended to the age of 21 years. Additionally, Section 4 Clause B of Hindu Minority and Guardianship Act 1956 states about the explanation of guardian, what guardian actually means. तो गार्जियन वैसे पर्सन होते हैं जो कि इन्वॉल्व होते हैं इन टेकिंग केयर ऑफ द माइनर प्रॉपर्टी, minor person, his affairs, and for the protection of minor. That particular person is considered as guardian under Section 4 Clause B of Hindu Minority and Guardianship Act. Now, there are different types of guardian that has been classified under Hindu Minority and Guardianship Act 1956. The very first is the natural guardian, second testamentary guardian, third guardian appointed under the Guardian and Ward Act 1890, and lastly de-facto and ad-hoc guardian. Now let's understand what natural guardian actually means. So the natural guardian actually means by those person who by the reason of natural relationship with the minor is considered to be a natural guardian. And the natural guardian relationship differ with respect to boy or unmarried girl, illegitimate boy or girl, and lastly the married girl. Now let's separately in the context of each of them. If we talk in the context of boy or unmarried girl, तो इन द केस ऑफ बॉय और अनमैरिड गर्ल द फादर जो होता है वो नेचुरल गार्जियन कंसिडर किया जाता है, एंड ही कैन टेक द कस्टडी ऑफ माइनर एट द फर्स्ट इंस्टेंस, बट and after that mother can take, but if the child is below the age of 5 years the mother is the natural guardian and he can take the custody of minor at the first instance. Now, if we talk in the context of illegitimate boy or girl, the mother is the natural guardian, and only after the mother take the custody, the father is entitled to take the custody and to be considered as a natural guardian. And additionally, if we talk in the context of married girl, the husband is the natural guardian of wife, and there is no point of considering father or mother as a natural guardian in the context of married girl. Now, if we talk about the restriction and some of the power of natural guardian under Hindu Minority and Guardianship Act, some of the restrictions is that the person who is acting as a natural guardian cannot be said to be act as a natural guardian if he or she is ceased to be a Hindu. And second point, if the person has completely and finally renounced the world by becoming a hermit, then that particular person cannot be considered as a natural guardian and cannot act as a natural guardian. Whereas Section 7 of Natural Guardian and Minority Hindu Minority and Guardianship Act 1956 in the context of natural guardian. The natural guardianship of an adopted son passes to his adoptive father and after adoptive father to adoptive mother because the transfer of child from the biological parent to the adoptive father makes the adoptive father and mother entitled to be considered as natural guardianship under Section 7 of Hindu Minority and Guardianship Act 1956. Now, if we talk about the powers that is enumerated under Section 8 of the Hindu Minority and Guardianship Act, so we will shortly discuss one or two points of the powers of the natural guardian. That the very first pointer is that necessary or reasonable acts for the benefit of minor. Suppose if any natural guardian acts reasonably or takes any necessary steps for the benefit of the minor, then this will be a valid step or this will be reasonable acts of the that particular person that falls within the ambit of section 8 that talks about the power of natural guardian. And second, if the natural guardian is enter into any kind of transaction that confers benefit upon the minor's estate or in respect of minor's person, then that transaction will bind the minor. And if that is not so like that, that the transaction entered by the natural guardian is leading to any benefit to the minor estate or the minor, then that particular transaction will not bind the minor at all. Now, let's understand what testamentary guardian actually means. So, testamentary guardian actually means that the guardian who has been appointed due to the will of a natural guardian is basically known as a testamentary guardian. Now, here, if we see in the context of legitimate boy or a girl, तो वहाँ पे जो नेचुरल गार्जियन होता है वो may appoint any person to act as the guardian of the child after the death of the father. And why after the death of the father? Because in the context of, as we have already seen, that in the context of legitimate boy or girl, father is the natural guardian at the first instance. And if the father died and if the mother is alive, then the mother will automatically become the natural guardian. And after her death, if she has not named any guardian, the person appointed by the father will become the guardian. As in as the mother has been appointed automatically as the natural guardian after the death of the father. But now, if the mother also died and the mother has not taken any name to be appointed as the guardian of the minor, then the particular person who has been nominated or who has been named by the father, that particular person will be appointed as the guardian of that particular minor. Now, a widow mother is a natural guardian and entitled to appoint a person to act as a guardian after her death, as we have already discussed in the case of legitimate boy or girl. Now, for an illegitimate child, the power of appointing a testamentary guardian lies only with the mother. So this is the same as like the natural guardian that in the context of illegitimate child, illegitimate boy or girl, the mother is the natural guardian and at the first instance, mother can take the custody. So this particular power of appointing the testamentary guardian after her death is also upon the mother at the first instance. सो अब जो टेस्टामेंट्री गार्जियन होता है और जो नेचुरल गार्जियन इन दोनों बहुत ही अलाइक है सिमिलर है विथ रिस्पेक्ट टू दी पावर्स और जो टेस्टामेंट्री गार्जियन होता है वो पर्सनली लायबल कभी नहीं होगा एंड फॉर मीटिंग द एक्सपेंसेस दैट हैज बीन इनकर्ड ऑन द माइनर्स प्रॉपर्टी और माइनर्स एस्टेट तो ही द टेस्टामेंट्री गार्जियन कैन आस्क फॉर द meeting of that particular expense through the property. Now, if we talk about the guardian appointed by court under Guardian and Ward Act 1890, तो यहाँ पे कुछ provisions है like section 13 clause 1, 13 clause 2, or if we talk combinedly about this particular thing that the welfare of the minor is the paramount importance in this particular act and for the appointment of guardian under Guardian and Ward Act 1890. Now, if we see section 13 clause 1, that talks about the appointment of any person as a guardian of a Hindu minor, but the court will first look that the appointment is being beneficial for the welfare of the minor or not. And if Section 132 Clause 2 additionally talks, if that particular appointment will not prove as beneficial for the welfare of the minor, then that particular person will not be entitled to the guardianship under Guardian and Ward Act 1890. Now, after understanding the testamentary guardian, guardian under Guardian and Ward Act 1890 and natural guardian, now understand the power of alienation concept. कि ये पावर ऑफ एलिनेशन का जो कॉन्सेप्ट है ये क्या होता है। तो पावर ऑफ एलिनेशन का कॉन्सेप्ट ये कहता है कि जो नेचुरल गार्जियन होता है हिंदू माइनर का, ही इज इंटाइटल्ड टू मैनेज द स्टेट और द प्रॉपर्टी ऑफ द माइनर एंड टू एक्ट रीजनेबली और नेसेसरी फॉर द बेनिफिट ऑफ द स्टेट। अगर कोई पार्ट अगर वो सेल करता है और मॉर्टगेज करता है एनी पार्ट ऑफ द प्रॉपर्टी, तो वो वैलिड होगा। बट अगर जो नेचुरल गार्जियन है ही हैज टेकन द प्रायर परमिशन फ्रॉम द कोर्ट फॉर सच एलिनेशन, एंड इफ दैट पर्टिकुलर नेचुरल गार्जियन हैज नॉट टेकन एनी सच प्रायर एलिनेशन परमिशन ऑफ द कोर्ट फॉर सच एलिनेशन, that that alienation will be considered invalid. Now, if we talk about who can apply for appointment as a guardian under Hindu Minority and Guardianship Act 1956, there are some of the requisites or the that needs to be looked before applying for appointment as a guardian and who can apply for the guardian. Now, the very first that is about talks about the intention, that desire of being claiming or doing being अपॉइंटिंग एज ए गार्जियन ऑफ द माइनर। ये इंटेंशन और डिजायर होना बहुत जरूरी है टू बी अपॉइंटिंग एज अ गार्जियन ऑफ द माइनर। अगर ये नहीं है तो ही कैनॉट बी अपॉइंटेड एज अ गार्जियन अंडर द हिंदू माइनॉरिटी एंड गार्जियंस एक्ट। आफ्टर दैट सेकेंड पॉइंट, एनी रिलेटिव और फ्रेंड ऑफ द माइनर, एनी क्लोज रिलेटिव और फार रिलेटिव और फ्रेंड who is entitled to apply for the appointment as a guardian under Hindu Minority and Guardianship Act. And after that, the collector of the district or the other local area जहाँ पे माइनर डिसाइड करता हो या माइनर होल्ड करता हो प्रॉपर्टी, अपना प्रॉपर्टी, वहाँ का कलेक्टर can apply for the appointment as a guardian under Hindu Minority and Guardianship. And lastly, the minor, if the minor belongs to a particular class, then the collector who has authority with respect to that particular class or who regulate or who control or who is the head of that particular class can also apply for to be appointed as a guardian of that particular minor under Hindu Minority and Guardianship Act 1956. So these are the valid requisites or the person that need who who can apply for the appointment as a guardian under this particular act. Now, आई होप आप सभी को ये वीडियो पसंद आया हो, समझ आया हो क्या गार्जियन होते हैं, क्या माइनर होते हैं, डिफरेंट टाइप्स ऑफ गार्जियनशिप एंड व्हाट आर द डिफरेंट फेसेट्स रिलेटेड टू द गार्जियनशिप अंडर द गार्ड एंड वार्ड एक्ट 1890 एंड सम ऑफ द प्रोविजंस ऑफ हिंदू माइनॉरिटी एंड गार्जियनशिप एक्ट ऑल्सो। सो आई होप और भी ऐसे आई होप आप सभी को ये वीडियो पसंद आया हो। और भी ऐसे वीडियो देखने के लिए हमारे चैनल को लाइक करें, सब्सक्राइब करें और रेगुलर नोटिफिकेशन पाने के लिए बेल आइकन को दबाएं। थैंक यू एवरीवन।